In their book, The Cycle of Juvenile Justice, the authors Thomas J. Bernard and Megan Kurlichek make many strong arguments throughout the book, and one of the key arguments they make is that by around the 1950s, the optimism surrounding the juvenile court had broken down. In the 1960s, during the backdrop of the Civil Rights Movement, the U.S. Supreme Court made key rulings which would provide juveniles with due process protections. And according to the authors, the court, in fact, laid the basis for the reintroduction of due process protections, which were seen in the 1868 case, which was referred to in the book as the O'Connell case. And as you may recall, in the O'Connell case, the Illinois State Supreme Court ruled that a young juvenile who had committed no crime could not be held in a reform school. Eventually, social reformers were able to nullify the O'Connell decision by establishing the juvenile court. However, almost 100 years after the O'Connell case, activist liberal justices of the Warren Court would return to the language and logic of the O'Connell case. You have probably heard of the Warren Court, as it marks one of the most liberal periods for the U.S. Supreme Court and occurred under the leadership of Chief Justice Earl Warren. Earl Warren was the Chief Justice between 1953 to 1969, and during this time, the U.S. Supreme Court was extremely concerned with civil liberties and civil rights, and it made rulings in favor of criminal defendants and inmates' rights advocates. One of the first and most important rulings that the U.S. Supreme Court made in regard to juvenile justice was the 1967 case In re Galt. In their book, Bernard and Kurlichek do a fairly nice job of laying out the facts of this case. They contend that Galt, who was a 15-year-old boy, made a prank phone call with his friend. The victim of this prank call then called the police, and later a judge would commit Galt to the State Industrial School for Boys until his 21st birthday. This is in spite of the fact that if an adult had committed this same offense, he or she would have only been required to spend a maximum of 2 months in jail. In the Galt case, the U.S. Supreme Court rejected the parens patria doctrine, which had permitted the juvenile court to flourish for the last 70 years. The justices made all of the arguments that had been seen in the O'Connell decision 100 years earlier. Additionally, the court held that juveniles should have certain due process protections, such as the right of notice to charges, the right to counsel, the right to confront and cross-examine witnesses, and the privilege of self-incrimination. In re Winship is another very important U.S. Supreme Court case that was an important victory for juvenile rights advocates. In this case, the court held that the beyond a reasonable doubt standard was required during the adjudicatory stage when a juvenile is charged with an act that would be a crime if committed by an adult. Prior to this ruling, a preponderance of the evidence standard was used. Preponderance had always been the standard of evidence used in juvenile courts because they were considered civil, not criminal courts. This was a huge victory for juvenile defendants. Also, the U.S. Supreme Court went a step further. They would later make this decision fully retroactive, meaning that youths who had previously been adjudicated based upon a ponderance of the evidence would either have to be released or re-adjudicated by evidence that was beyond a reasonable doubt. This was an unusual step, and it is something that the U.S. Supreme Court seldom does. In 1971, the U.S. Supreme Court reversed itself in the McIver decision. In McIver versus Pennsylvania, the court ruled that the Constitution does not require a trial by jury at the adjudication stage of juvenile justice processing. In the majority opinion for this case, the court reasoned that juries would be highly disruptive of the informal, cooperative nature of juvenile court proceedings. In short, juries create an adversarial atmosphere according to the logic of this case. And it should be noted that some states do allow juveniles to have a jury during juvenile court proceedings. However, the U.S. Supreme Court ruled in the McIver case that this is not required by the Constitution. One might ask why the court seemed to reverse itself by not permitting juveniles to have juries. After all, the court had given juvenile defendants so many rights in both the Galt and the Winship case. So given this, why did it not give juveniles the right to a jury? This is, in fact, an important question and is worthy of more discussion and analysis. In their book, the authors provide two plausible explanations. As you read this aspect of the book, try to think of additional reasons as to why the court may have decided not to grant juvenile defendants with juries during a time where it expanded civil rights in regard to juvenile justice. The U.S. Supreme Court established a new constitutional juvenile court that was intended to provide juveniles with due process protections in addition to the care and treatment which has been associated with the juvenile court. As it turned out, juvenile hearings, being driven by a broader Get Tough on Crime movement, were eventually given a strong emphasis toward punishment. According to Bernard and Kurlichek, in a post-Galt courtroom, prosecutors have become much more focused on representing the interests of the state rather than the juvenile. Also, gone are the days when a benevolent, fatherly judge listened solely to the recommendation of a juvenile probation officer who had conducted an investigation into the social history of the youth. Also, the vision of the liberal Warren Court never fully came to fruition. In fact, the redefinition of delinquents as modified criminal defendants may have actually undermined the juvenile court's ability to focus on the care and treatment of the juvenile. The U.S. Supreme Court attempted to restrict the power of the state in juvenile courts by providing due process safeguards. However, today, juvenile court justices often encourage defendants to go to trial without a lawyer. And when a lawyer is provided by the court, he or she tends to be poorly trained, poorly paid, and often severely overworked. Also, as mentioned earlier, the state managed to find a loophole by which to expand its power after juveniles were provided with these safeguards. Since the juvenile was given more rights as a result of U.S. Supreme Court decisions, the state expanded the role of prosecutors. And today, the prosecutor is trained to protect society from young criminals as opposed to protecting the best interests of the child. Also, because the U.S. Supreme Court never provided defendants in the juvenile court with either the right to a trial by jury or the right to appeal, this has allowed the state to further trample upon the rights of juveniles. The Supreme Court's vision of due process for juveniles in the juvenile court was never implemented. In fact, it may have inadvertently created a Get Tough movement which prompted prosecutors to aggressively pursue juvenile defendants. The Supreme Court essentially defined juvenile delinquents as slightly modified criminal defendants, and according to Bernard and Kurlichek, it was only a short deductive step from the idea that juveniles are small criminal defendants to the idea that juvenile delinquents are in fact small criminals. This was the step taken by the Get Tough movement. During the 1980s and 1990s, the Get Tough movement was accelerated by violent crime, especially violent gun crime, which occurred within inner city areas. Even though this gun violence was restricted to a very limited geographical area, it nevertheless made national news headlines and prompted politicians and justice officials to get tough on juvenile crime. The due process movement of the 1960s consisted of a number of court cases at the national level. However, the Get Tough movement occurred primarily at the state level, where each state legislature passed its own version of Get Tough policies. While the traditional juvenile court had protected the privacy of those involved, legislation passed during the Get Tough movement allowed for, and in some cases even required, juvenile justice arrestees to be photographed and printed. This sends a very powerful message to the juvenile that he or she is indeed a criminal. Also, today, juvenile court records are now officially released. So, the confidentiality of these proceedings has been altered, which can have a negative impact on a juvenile's future educational and career opportunities. Today, almost half of all states allow the public or media into juvenile courtrooms under certain circumstances. Also, the role of the prosecutor has greatly expanded. Today, it is the prosecutor, not the probation worker, who typically decides who is formally processed and who is not formally processed. Also, today, victims of juvenile crimes are often afforded the opportunity to submit a victim impact statement to the court. This also reflects an orientation which is geared toward punishment. It turns out that the Supreme Court's due process reforms were simply not implemented. The ideals of the 1960s Warren Court not only failed to come to fruition, they were instead largely abandoned in favor of a Get Tough movement with a focus on punishment.